Hello and welcome to the Rodgers Brief. It is December 29th, 2024, and this is going to be a special edition of the Rodgers Brief. What I'm going to be doing on this episode is covering the top 10 stories of the year, and these are stories for anybody new to the program. What I do here is cover stories that are either cases that have been decided by the Supreme Court of Canada, other Supreme Courts throughout the country, some international stories, or else stories that have a legal angle to them in one way or another. New legislation being introduced, or certain cases, inquiries that are ongoing. And that's going to cover a few of the stories of the top 10 this year. When I started doing this channel, it was to cover the Mass Casualty Commission in Nova Scotia, which of course something of national importance and made national news on a regular basis after the shootings here in Nova Scotia. And I've expanded this to cover, stories that are just of interest or that are of national importance, or stories that I think may have a legal angle that's been either misunderstood or underappreciated in some way. So that's what I try to do here, and it's been a lot of fun to cover these stories. I was looking back at the last episode I did in 2023 just to see where we've gone over the course of the year. And at that point, it was an update on the Mass Casualty Commission report, the Progress Monitoring Committee, which at that point was chaired by retired Court of Appeal Justice Linda Oland. That was given an update at the time, and at that time the RCMP had not provided their update as they were supposed to, and all these kinds of things. So we'll talk about that in a minute. The other thing that was going on a year ago was the U.S. Supreme Court was preparing to hear submissions on whether the President of the United States enjoyed criminal immunity for certain acts. And I talked about that at the time and predicted where it was going to go, which was basically to say, well, if the act is at all political in a sense that it covers part of the president's duties, then that's going to be subject to immunity from criminal prosecution, which is exactly what the Supreme Court said. Of course, a lot of people freaked out at that, but it doesn't say that anything the president does gives the president immunity, which is what some of the critics of the decision claim that it says. Anyway, that was a year ago. Lots happened since then. And so let's just jump right into the first story, which is over the course of the year, the Mass Casualty Commission Progress Monitoring Committee has been providing some updates. They have a new chair in place. That is Myra Freeman, the former Lieutenant Governor of Nova Scotia. What happened? Well, at the first of the year, like I mentioned, the RCMP missed their deadline to give an update. And then a few months later, when they did, they gave what most would consider a fairly empty report on the progress that they have made, or the work that they've been doing to put in place the recommendations from the Mass Casualty Commission. Not too many people now, I think, would say that people are talking about replacing the RCMP as much as they were during the Mass Casualty Commission. One might wonder whether the RCMP has weathered the storm of the Mass Casualty Commission scrutiny, because what else has happened? Well, it wasn't really talked about much during the provincial election recently in Nova Scotia. And so what else has happened? Well, they've come out with an annual report just a few weeks ago, chaired by Myra Freeman now. Some critiques from participant Christina Fifield on the lack of progress on domestic violence policy adjustments as was recommended. Well, there's certainly, in my observation, been no changes to police or Crown prosecution policy when it comes to domestic violence prosecutions cases. So what has changed? It's been kept very quiet. The biggest news out of there was when the commission, they talked about the intimate partner violence in Nova Scotia being a quote-unquote epidemic. the Justice Minister at the time, Brad Johns, kind of, he wasn't sure whether he agreed with that definition, and he was quickly kicked out of caucus or out of cabinet or resigned from cabinet before he was kicked out, I guess. So that's been about it. So $40 million plus to the Mass Casualty Commission for what? One of the things I mentioned during the commission itself was that I didn't think the commission was really engendering a lot of public support for what they were doing. I didn't think they were the way they went about the commission didn't bring the public in enough. And so now we're seeing the fruits of that, which is that the public is not demanding changes that the commission recommended. It did not come up during the election at all. And so all this money, $40 million plus, maybe more than that, for what? It's not sure. So we'll talk about this more, I'm sure, on the Sunday night Canadian Crime Weekly when I get back on in the new year with Paul Palango and Jordan Bonaparte. I know Paul has his second book on the shootings coming out in 2025. Can't wait to see it and see if that maybe is what it takes to get the conversation going again on these recommendations. So what else? All right, so that's story number one, has been the Mass Casualty Commission updates, which has been, the story is, very little has happened as a result of this sort of, at the time, all-encompassing Mass Casualty Commission. Story number two, another inquiry, which is the Foreign Interference Inquiry. This is ongoing now. As I'm recording this, I'm recording this before the final report comes out, but the final report is due to come out by December 31st, so just in a few days' time. This has been an interesting inquiry. I think we know what kind of recommendations are going to be made, that parties should be more, political parties that is, should be more alive to what takes place in their nomination battles, leadership contests, that sometimes the interference starts at that stage. It doesn't just, yes, there's foreign interference in terms of advertising, misinformation on social media, those kinds of things from China, Russia, India, as we're learning. But we'll see what comes out in Justice Marie Hogue's report. Seems like she's been doing a good job as chair of the inquiry, and so I've some hope for what emerges from this. What have some of the highlights so far over the course of the year? First of all, the Conservative Party was denied standing at the inquiry. Some of their members, like Michael Chong, received standing, but not the party itself. That was an interesting start to it, although it seems like either through the inquiry itself or through parliamentary committees, the Conservative Party certainly had their say. Some MPs were said by Justice Marie Hogue and CSIS to be witting participants in foreign interference efforts. So we'll see what more detail on that emerges in the report. And so the question will be, when we have an election coming up, by the way, an election coming up probably now in March, it looks like, if when Parliament comes back at the end of January. I know the Conservatives announced just yesterday or the day before that they were going to be proposing a non-confidence motion through a Public Accounts Committee that would bring a report back into Parliament, so that Parliament wouldn't have to, so that the party would not have to wait for an opposition day to be allocated to it in order to make that non-confidence motion. Anyway, so this next election looks like it'll be held probably in March. And will there be a different system next time? The existing system, we learned through this inquiry, had a very high threshold before any information would be deemed serious enough to reveal to the public. It had to have an effect not on just one riding, but on the election as a whole, before it was considered by this committee of bureaucrats to be important enough to release to the public. I think that'll be a recommended change, that even if it affects one riding, that should be public information. All right. So that's one thing that's going to affect the next upcoming election. Another one is story number 3, and this is a very localized story, but it was something I covered because I was involved in it in a sense, which is the electoral boundaries decision for the federal riding of Cape Breton, Canso, Antigonish, new riding where I'm seeking the nomination as the Conservative candidate, full disclosure. But before this, way before this, when the Electoral Boundaries Commission was going around, it's a couple of years ago now, to examine new boundaries in Nova Scotia, one of the recommendations I made was this change to the 2 Cape Breton ridings, one which also bleeds over into the mainland, to align them more on an urban-rural basis so that Sydney and Glace Bay would be one riding and those communities, and then the rest of Cape Breton and eastern Nova Scotia, which are more rural and aligned in other ways as well through health systems and other things, that would be a second riding, better community of interest and all kinds of reasons for that. I remember being at the electoral boundaries hearings in Antigonish. Minister Sean Fraser was there advocating for the existing boundaries, which seemed clear at the time wasn't going to win the day. So the Boundaries Commission agreed basically with my submission. I know others made the same or similar submissions. Then it was challenged through the MP Jaime Batiste, saying that it was improper, that it was a result of improper lack of consultation with the community of Eskasoni. That went back to the commission. They disagreed, wrote a very compelling decision as to why they disagreed with that. The community of Eskasoni, led by Chief Leroy Denny and supported by Jaime Batiste, then took that to the federal court, lost that decision just about a month ago. And so now the boundaries set, and the election will be held under the new boundaries, as it should be. So that was an interesting sort of ongoing saga. It went through a parliamentary committee as well, dominated by Liberal members, which voted to study the matter, I think, or to support a change, or ask the boundaries to examine whether they'd make a change. And that, the process was driven by Jaime Batiste, but that's where it ended up. Okay, so that's story number 3. Story number 4, the Emergencies Act decision. So this is another federal court decision. Federal court declared that the government was unreasonable in invoking the Emergencies Act during the trucker convoy, freedom convoy, whatever you want to call it. Judge Richard Mosley wrote the decision, very compelling decision, that there was no quote-unquote national emergency apparent, which was beyond the capacities of existing law enforcement resources and laws to confront. So now, interestingly and significantly, I guess you would say, Justice Rouleau of the Rouleau Commission that was needs to be called anytime the Emergencies Act is invoked, the Commissioner Rouleau disagreed, said that there was enough of an emergency to justify the invocation of the Act. Federal court disagreed, so they said there was a charter violation. It was a charter violation to seize the assets, freeze bank accounts of people involved or sort of peripherally involved in the protests. Now, what is happening with this? It's not over. The federal government appealed the decision almost immediately, and the appeal is set to be heard. This hasn't really been in the news. The appeal is set to be heard. I looked this up on the federal court website on February 4th, 2025. Now, here's an interesting timing question. We could be into a federal election at that point, an election which is likely to elect the Conservative Party to government. So the Conservative Party would be unlikely to want to pursue this appeal. I would say if the election happens when it is likely to happen in the next couple of months, this appeal hearing may still take place on February 4th, but it may still, the Court of Appeal, the Federal Court of Appeal, may still be deliberating while the election, as the election is decided. A new government might come in and pull this appeal, and then we'll never see what the Federal Court of Appeal says about it. Now, it seems, well, it could go either way, but Judge Richard Mosley's decision I thought was very well done. Seemed likely to withstand appeal. We may see. Story number 5. Online Harms Act. This piece of legislation has not been enacted yet, but it was debated and in the news much of the year. Federal government trying to do something with the internet and free speech and trying to make that balance work between, the good parts of the internet and the bad parts. There were 2 parts of the legislation. One was dealing with, children and vulnerable individuals, intimate images, bans on sharing intimate images and all these things. All parties seem generally in support of that. Of course, there's always, fine tuning that can be done on things, but that part of the legislation was being supported. The other part was not. This was restrictions on free speech and, forcing platforms to do certain things based on, offensive speech or, basically offensive speech. When this legislation was introduced, the government, it was a very unusual situation because anytime the government introduces legislation, they are required to provide a charter statement, a statement that says, we believe as a government that this legislation is compliant with the Charter of Rights and Freedoms, and here is our explanation as to why we think that. They didn't do that with the Online Harms Act till much, much later. It was months later before they provided a charter statement. The charter statement wasn't particularly persuasive, so in the fall, the government decided, they thought, well, maybe we'll split the legislation and just do the first part, but because Parliament has been at a bit of a standstill all fall due to, parties have asked the government to provide information on an environmental tech fund, slush fund, it looks like. Government has refused to do so, and there's been a standstill. Lots of legislation that was sort of sitting poised to be passed has not gone through those steps, including the Online Harms Act, so that has not passed. The incoming government, one might say, the Conservative Party has put out a proposal that basically does part 1 of the Online Harms Act in a slightly different way and forces the platforms to do a lot of the work that would be required for that, and doesn't touch the free speech side of it, just part 1. So we'll see when that government is elected, if it is elected, what that legislation looks like. Next 2 stories, 6 and 7, deal with youth crime. One's out of the United States, one's out of Nova Scotia. Different ways of treating these things, different situations, granted, too. The one out of the United States, out of Michigan, this is new. 2 Michigan parents, mother and father, were charged and convicted of involuntary manslaughter after their 15-year-old son committed a school shooting. Jennifer and James Crumbly, what did they do? They provided the gun to their son, who had all kinds of mental health issues, disorders, and the parents, ignored those mental health warnings. Tragic situation. I mean, the kid was, he was detained in the school and then let back into the classroom. Nobody thought to check his backpack where a loaded gun was found. Well, that's where it was located. So in this case, the parents, basically a negligence type claim for negligently raising their child and then providing a negligently raised child with a deadly weapon under circumstances when it was likely he was going to use it. So we've seen a couple of those now being prosecuted by parents, that is, being prosecuted in the U.S. Would not be surprised if that comes across the border into Canada. It had to be under specific circumstances, but now that door has been definitely opened and is not going to close. Story number 7, different youth matter, but stabbing in Bedford, Nova Scotia, at a school, C.P. Allen. And this is the controversy in this case was right away the youth Crown office in Halifax announced that they were going to try to have the youth sentenced as an adult. They were seeking jail time for him, significant sentence sought. And I've spoken to some defense lawyers in the city who, because that shocked me to hear that they were thinking of that. Now I've seen other cases now, the Halifax shopping center killing, right away they announced that they were going to seek an adult sentence, before anybody knew the circumstances, including, I'm sure, the Crown and the police. They didn't have a fulsome understanding of the circumstances yet were announcing this. So what I've heard from defense lawyers in Halifax is you basically don't even bother dealing with the Crown, which is unfortunate because that's where a lot of work happens. You go and you just have to take it to the judge, take it to court. So in this case, guilty pleas were entered. This is a 15-year-old high achiever, an IP student, who didn't like furries apparently, and put up some posters around the school with, suggestive of with crosshairs and these kinds of things. He was under all kinds of pressure and had made threats of self-harm, and then ended up stabbing a vice principal and stabbed an admin assistant as well. And then went out and was trying to kill himself immediately afterwards, had to intervene. The intervention was required. And the kid went off to a juvenile facility for a while and then was under strict conditions, sentenced by Judge Elizabeth Buckle to 2 years of probation. The victim, the admin assistant, apparently walked out during the sentencing hearing, which is a big no-no. You don't do those kinds of things in courts in Canada. The judge also took into account the fact that this is a youth, their identity is protected. One of the sheriffs that was on the case initially shared a photo of the kid online, and the sheriff was subsequently fired once that was found out. Anyway, it's a tragic story, and hopefully the young person will be able to get help. The adults, they were stabbed, so they have some issues as a result of some PTSD and that kind of thing, but they've survived as well. So that was a story that got in the news quite a bit here in Nova Scotia, and kind of indicative of a few things of how youth justice works in this country. Another Nova Scotia story that was news, this is sort of coming out of the pandemic in a sense, which you don't see too many cases of these anymore. But, so this is Judge Rickola Brinton, who, when the pandemic was on, refused to take the vaccine. And so she was taken off the bench. Eventually, so some of the consequences of that were that so she wasn't allowed to sit in any way, and she sued the chief judge of the provincial court, Pam Williams, and sued for millions of dollars because saying, well, I was a judge making a lot of money, and now I can't be a judge anymore. It's your fault because you wouldn't let me be a judge without taking the vaccine, and therefore loss of millions of dollars in future earnings. The lawsuit failed. It was subject to a summary judgment, which means a judge thought there's no kind of a case here. Just what you're pleading is not legitimate. The chief judge makes decisions in this realm in a role as chief judge, and she's immune from prosecution and from litigation in that role. So the lawsuit failed immediately. So a huge mistake by Judge Brinton to take that lawsuit to start that lawsuit, but to stay off the bench. One of the cases, so there was a few cases that she had where the delay from her, like she had heard the evidence, hadn't rendered a decision, and so months and months go by. A new judge has to come in. What happens then? Is it going to be a retrial? Is the judge going to be able to just decide based? So there was a few cases where the delay, was so long that the cases were thrown out under Section 11 Charter breach for Yeah, a person has the right to be tried within a reasonable time. There's also decision delay too. So once the evidence is in and you get, months before a decision is made, that in itself is a charter violation. In this case, one of them was Brandon McNeil, related distantly, I think, to the former premier, but who had been charged with sexual assault, sexual exploitation, and sexual interference of two children. Dartmouth case, and that decision, seemed likely that he would have been convicted, but the case was thrown out because of the delay. So there's some consequences to Judge Brinton's decision, not only personally to her, big consequences there, but also consequences to the public. All right, so that was story number 8. Story number 9, a story of the Barrister Society in Nova Scotia. When the George Floyd protests were taking place, many organizations issued statements, in support of Black Lives Matter, protesters, and the movement generally, and all these things. So did the Barrister Society. Well, there was a complaint received that, how can the Barrister Society, it was submitted, not always perfect in terms of racial treatment of, racialized individuals, lawyers in the community, and the community generally. How can you say something like that, in support of the Black Lives Matter protests? So that set off a series of events which led to Douglas Ruck, African Nova Scotia lawyer, senior lawyer, well-respected, award-winning lawyer, being tasked with doing a report to the lawyers of Nova Scotia through the Barrister Society on racism within the profession or within the Barrister Society itself. And so he comes out with this report, and the Barrister Society was so happy to receive it and all these things. But what did it say? So it originated a little bit through the Lyle Howe situation, so there's the George Floyd statement that the Barrister Society made, and then there was the Lyle Howe prosecution. Lyle Howe, a young African Nova Scotia lawyer, prosecuted for, being double booked and, behavior associated with his practice, which some people thought was, and certainly Lyle Howe thought, was reflective of his skin color as much as anything else about his conduct. Whereas, other white lawyers doing the same thing got away with it. So I was looking forward to reading this Ruck report to see what he would say. Well, he didn't say anything really about the George Floyd comments other than that's what initiated this process. He didn't explain why or if he thought the Barrister Society's statement was incorrect or a problem in any particular way. He did say that he writing his report assuming there is systemic racism within the organization and the profession. Not an unfair way to start the report, but maybe skips some important steps that would have helped the report land a little better. Also, he didn't say anything about Lyle Howe's situation. Like, I was waiting for, the case to be discussed. The only thing, he didn't tie this to the Lyle Howe situation. He said that if any equity deserving, so by the way, this term was throughout the report. What do you call a lawyer who comes from a minority background? Equity deserving is what Douglas Ruck calls them. So what does that mean? Well, it avoids the difficult task of trying to parse out who is equity deserving and why. Is it because of their gender, because of their skin color, because of their background, because of the whatever community they came from? What does it mean? Well, We don't really know. It's a broad definition. We kind of know, but don't really know. He didn't really explain what it was. But what it means is that anybody who is from an equity deserving situation, if they make a complaint, sorry, if they are the subject of a complaint, it's not quite clear if they make a complaint, but I think so. But certainly if they are subject of a complaint that somebody on the panel, 3-person panel or whatever is, whoever's investigating it, they should also be from an equity deserving community or background, just so that there is some appreciation or understanding maybe of the unique nature of the person's scenario. Okay, so that's about it. That's the only real change that is apparent from the tremendous effort that went into the Ruck report. Bit of a theme here with these reports and efforts and lots of money going into them and seemingly very little change taking place. Unfortunately, that is also the theme of story number 10, which is also kind of personal to me, which was the Desmond Inquiry report. Came out at the end of January. From Judge Paul Scoville, provincial court judge who was assigned to the inquiry after the end of the hearings. The hearings were led by Judge Zimmer, who was on the inquiry for years, thinking about nothing but the inquiry, and that was it, and doing the hearings and organizing the experts and thinking about all these complicated issues of military health records and PTSD and microaggressions of racialized people or towards racialized people who go in to access health services. Lots of complex issues, dissociative disorders, but because he was past the age of 75 and can only get, he had been given a few extensions. That's the mandatory retirement age for judges. Judge Zimmer, because the pandemic pushed the inquiry back, he was given a few extensions by the government, but ultimately was not extended further, and they removed him, brought in Judge Scoville, who had to start from scratch, read what he could about the inquiry and come out with a report. Good report, but the change in judges took the wind out of the sails big time, and nothing's happened since. That would be a fair thing to say. There was no committee formed to oversee the recommendations, no obvious effort on the part of the Justice Department, the Veterans Affairs Department federally, or the provincial government generally. It was not brought up in the last provincial election to implement the recommendations from the Desmond Inquiry report. So lots of good ideas out there, but not a lot of implementation of good ideas taking place throughout. So that maybe is the theme of the top 10 stories. Not all of them that way, but certainly some of them. And that's been an interesting year to see these big, societal affecting or potentially affecting changes recommended, and then to see them not take place. But lots of inquiries and things taking place. I hope that everybody has enjoyed the year in law. It's been an interesting year that way. Certainly lots of interesting cases happening. So these are the top 10 sort of things that I've been watching. I've seen other top 10 lists of like Supreme Court cases that Justice Derrick put on, and other kind of top 10 story lists, and I encourage you to check all those out as well. And otherwise, I'll be back in 2025 with more episodes of the Rodgers Brief, and hope to see you again there. And join me again, and we'll keep you up to date on all the happenings in law, the cases, new legislation from Nova Scotia and across the country, and significant stories from around the world as they seem relevant to us. Okay, that's it for 2024. Happy New Year to everybody, and we'll see you next year.